Welcome back to Vic Property Law, where we help you understand the basics of conveyancing and property law in Australia. Today's episode is about the real estate agent's favourite document, the Section 27, or the early release of deposit. We'll detail a bit about the process and why real estate agents love it so much. Now, before we begin, as always, check in with your lawyer or your conveyancer before you just take our advice on everything. And if you haven't already, be sure to like, subscribe and share. Now, let's begin. Starting off, we'll be discussing why it's called a Section 27, exactly what a Section 27 does, the difference between having a mortgage and not having a mortgage with regards to a Section 27, the ways that deposit gets released, why the real estate agent loves it, and finally, what a purchaser's caveat is. The Section 27, or early release of deposit, refers to the legislation that we spoke about in the last video, the Sale of Land Act 1962. But this time, we're looking at Section 27. Lawyers, conveyancers and real estate agents alike use Section 27 for short. Anyone that's not a real estate agent really loves the Section 27 and its whole process. It's usually their favourite part of the whole process. Just ask your lawyer or conveyancer. You'll be sure to hear their favourite part is always the Section 27. Now keep in mind, if you're buying or selling in a state that's not Victoria, Section 27s don't apply. A Section 27, or early release of deposit, allows the vendor to precisely do that, to access the deposit prior to the date of settlement for their own use. Most vendors want the funds for one of two reasons. They want to use that money to put it onto a deposit for another house they're most likely purchasing. Or two, the real estate agent has talked them into it. Now the sole purpose of the Section 27 is to release the deposit held in the real estate agent's trust account. We'll tell you why the real estate agent loves it so much at the very end of the video. We want to keep you watching right through. We'll start with the easy one first, and then take you through the more complex one. If you have no mortgage over your property, or no home loan you're paying for, then your lawyer will merely send a Section 27 document confirming that there's no mortgage and no caveats over the property. Once the purchaser signs and their lawyer sends the Section 27 fully signed back to the real estate agent and your lawyer, that's it. It's ready to be released. If you have a mortgage over the title, this then becomes quite a slow process. The bank needs to receive instructions, usually by way of what's called a discharge of mortgage form. And in that form, the boxes for requesting a Section 27 need to be ticked. Your bank will then prepare what's called a Section 27 supporting letter. The Section 27 supporting letter from your bank outlines all the particulars of the mortgage and whether the person paying the mortgage is in default or has payments outstanding. This document lets the purchaser know all the details of the mortgage. It's almost like a smaller version of the vendor's statement. Remember that thing from the last video? The Section 27 and the Section 27 supporting letter need to be provided to the purchaser's lawyer or conveyancer. They will then present this to their client and either formally object or get their client to sign it. If they object, generally the vendor's lawyer will try to fix the issues raised so it can be released. If there are no objections and the purchaser signs, the Section 27 gets sent to the real estate agent and they will then release the monies to the vendor. The purchaser has 28 days to sign or object to the release of the deposit. If they don't object or sign that Section 27 within that time frame, the vendor has the right to then get the real estate agent to release that deposit. as long as the 28 days notice has passed, of course. As a purchaser, you really want to make sure you read all the documents from your lawyer and really make sure you understand what's happening and the details that you're signing off on. Finally, if there is any condition that is for the benefit of the purchaser can reasonably object to the deposit being released till that condition is satisfied. That's how it gets released. But now moving on to what we all wanted to hear about. The age-old question. Lawyers and conveyancers have wondered about this for years. How is it that a real estate agent just loves the vendor that much? They want to help them get the deposit nice and early. What's in it for the real estate agent? Oh, that's right, they get their commission accessed early too. Not bad if you're a real estate agent. Who doesn't love payday if it comes early? Before you accept the release of deposit, make sure you check with your lawyer if it's a good idea to do so. They may have some ways to protect your interests, like in the next slides. A purchaser's caveat registers the purchaser's right or interest to the property from the date of the contract to the date they take full legal possession of the property. It allows you to stop the vendor from trying to collect a few deposits from a range of purchasers, as it becomes a blemish on the title that must be removed before settlement can happen. This is a very useful way to make sure you've protected yourself properly. It usually comes at an extra fee with your lawyer or conveyancer, but if your settlement is longer than 45 days, it might just be a good idea to protect yourself. Now, if you're watching our videos, and we're sure you are, you're probably feeling like a bit of a master right now. And it might be time to check with your lawyer or write a question in the comments box to get a little bit more info. You never know. The Vic Property Law guru might just respond with an answer. As always, we'll see you next time.